Welcome to this session on the new data sharing code. Who's afraid of data sharing? Myth busting and the ICO's regulatory approach to data sharing. My name's Viv Adams. I'm Principal Policy Advisor in the Parliament and Government Affairs team at the ICO's Wilmslow office. And I'll be assisted today by my colleague Leanne Meredith at our Cardiff office, who'll be assisting with questions in this session. Leanne?
Good afternoon, everyone. Thank you so much for joining. I'm the Lead Policy Officer for the ICO in Wales. It's lovely to be here.
Thank you. And Will Johnson, who works in the ICO's High Priority Inquiries team, will be joining me to discuss a real-life case study later on.
Hi, everyone. Glad to be here and I hope you're having a good day so far.
Okay. You're welcome to ask questions in the chat box throughout the session. We'll look at these at the end of the seminar. This is a short session, which is why we are running 3 seminars, and we probably won't have time to answer all of them in the session due to time. We'll aim to pick up the most salient ones in the session. For those we don't have time to answer today, after today, we'll aggregate the questions received and feed them and our responses into our data sharing information hub to ensure that the main issues are covered. So keep an eye on the hub on our website in the coming weeks. We're keen for you to participate in our data sharing work, as I'll emphasise in this session and have done in the first session and will do in the later session. And we want to develop the hub into a resource that is relevant, reactive and live. This and the other sessions will be available online later. Here's some basic information about the code and the legislation requiring it to be produced. The Data Protection Act 2018, DPA 2018 for short, requires the Information Commissioner to prepare a code of practice, and here it is on the slide, providing practical guidance on data sharing, and that guided us in our production of the code. The new code was published on our website in December 2020. We expect it to be laid before Parliament soon. Now, the code takes an enabling approach to data sharing. It explains and provides practical examples to help you. Emphasis on practical as required by the DPA 2018. Our aim is for the code and the complementary resources in the Data Sharing Information Hub to help you feel more confident about data sharing. To help give you that confidence, we've also dispelled myths, used examples and case studies, and explained our regulatory approach. Now, in this session, we aim to examine those myths and misunderstandings surrounding data sharing, explain our regulatory approach to data sharing, which is sometimes misunderstood, and promote confident, proportionate data sharing. Now, before writing the new code, we were conscious that there are a number of myths and misconceptions around data sharing. We wanted to dispel these with myth-busting messages in both the code and in the new Data Sharing Information Hub. And the hub itself will continue to develop. We want to include more case studies and know what other resources would be useful to you. And we'd like your help with that, please. Please email us at datasharingcode, that's one word lowercase, datasharingcode@ico.org.uk. So the code and the hub together explain that data protection law enables data sharing, providing a positive framework to share data fairly and proportionately. And they also aim to dispel myths and misconceptions. And you can see there's a screenshot here from the hub data sharing myths busted. We acknowledge that the code of practice is not a panacea to solve all data sharing challenges, as the Commissioner emphasised in her foreword to the code. Aside from the myths that are around, we're conscious that other barriers remain to organisations feeling confident to share data. Yes, some are ones of perception, but I'm not going to patronise you. We know there are real challenges such as cultural, technical and organisational factors. This is something on which many parties will need to work together. Collective effort is needed from practitioners, government, as well as the ICO, and the code is a milestone along the way. We have made a start. The next few slides return to the topic of the myths and misconceptions around data sharing. Coming up are some questions for you all to answer using the means that were explained to you on joining. And we'll return to your answers later in the session. Note that more than one answer might be correct. So myth-busting question 1. Have the UK GDPR and DPA 2018 created additional barriers to data sharing? A, yes, but only where you are sharing large volumes of data. B, yes, but only where you are sharing special category data. And C, no, they have not created additional barriers to data sharing. I'll move on to the next one. Myth-busting question 2. Can we share data in an emergency? A, yes, you can share data in an emergency. B, yes, but only after a data protection impact assessment, DPIA, has been carried out. Or C, rarely. And finally, myth-busting question 3. Is there much benefit to sharing data? A, yes, data sharing often brings benefits to organisations. B, yes, data sharing often brings benefits to individuals and to society as a whole. And C, no, any benefits that result from data sharing are usually outweighed by negative aspects, such as potential risks to the rights and freedoms of individuals. We'll look at how you answered shortly. This slide looks at a case example illustrating the use of the lawful basis of data sharing required by law, in which consent wasn't required, because sometimes people think that consent is the best lawful basis to use, and it actually often isn't. It is not always appropriate where there's an imbalance of power, for example. Often there's a better one to use. The slide summarises the facts, but I'll just give you more detail. A local authority was required by law to participate in a nationwide anti-fraud exercise that involved disclosing personal data about its employees to an anti-fraud body. The exercise was intended to detect local authority employees who were illegally claiming benefits that they were not entitled to. Even though the sharing was required by law, the local authority still had to inform any employees affected. that data about them was going to be shared, and still had to explain why this was taking place, unless this would have prejudiced proceedings, so they needed to consider that carefully. The local authority had to say what data items were going to be shared, names, addresses, and national insurance numbers, and to provide the identity of the organisation they would be shared with. There was no need for the local authority to seek employees' consent for the sharing, because the law says that the sharing could take place without consent here. The local authority also had to be clear with its employees that even if they objected to the sharing, it would still take place. The local authority had to be prepared to investigate complaints from any employees who believed they had been treated unfairly because, for example, their records had been mixed up with those of an employee with the same name. So that's just one example. Another example, we emphasise in the code that you can and you should share data in an emergency. However, it's good practice to plan ahead as far as possible, and this example illustrates that. The police, the fire service and local councils met to plan for identifying and assisting vulnerable people in their area for an emergency, in an emergency situation, such as a flood or a major fire. As part of the process, they determined what type of personal data they each held and put in place a data sharing agreement to set out what they would share and how they would share it in an emergency. They reviewed this plan at regular scheduled intervals. We have a whole section in the code on data sharing in an emergency situation or in an emergency. We're now going to discuss with you a practical example, a case featuring a data sharing scenario during the COVID pandemic. I'll introduce you again to my colleague, Will Johnson, a senior policy officer in our high priority inquiries team. Hi, Will.
Hi, Viv.
Over to you.
Thanks very much, Viv, and hello, everybody. The example I'd like to discuss is the sharing of personal data with supermarkets during the pandemic. And this was about providing priority deliveries to people who were shielding.
This is the basics of the facts, and Will's going to talk us through it. This is an interesting one. So what was the situation, Will?
Right, well, firstly, I should say that authorities across the devolved regions of the UK each took steps to support vulnerable people involving data sharing. Each region took a slightly different approach, and so with apologies to anyone listening from Wales, Scotland or Northern Ireland, I'm just going to focus on the situation in England purely because that's been my own area of focus. But to give you some background, if we cast our minds back to early 2020, COVID-19 was still new to us. And at the start of the pandemic, the Chief Medical Officer for England asked NHS Digital to create what was called the Shielded Patient List. This was a list of patients in England who had been identified as being at a much higher risk of getting complications from COVID-19 because of their pre-existing medical conditions. Now, people on the list were referred to as clinically extremely vulnerable, and they were sent a letter at the time which advised them various different things, but amongst other things, to stay at home and what we now call shield for 12 weeks. Of course, that advice has evolved over time, but back at the start, that was the situation. The list was also used for other things, planning, analysis, wider research into the disease, that kind of thing.
So this information was being used for a range of things then, by the sound of it.
Yeah, that's right. There were various things happening, including helping people get deliveries of medicines from pharmacies. We won't be able to cover all those things in detail today. I'm just going to focus on the specific example of supermarkets. As I say, people on the list were advised to stay at home and shield for 12 weeks, whereas other people, we were all told, weren't we, that we had to stay at home, but we were at least able to leave to go and buy food supplies from shops. I think many of us will remember that even going into a supermarket didn't mean you could get what you wanted. Shelves were empty. Now, a year down the line, I think it's fair to say that supermarkets have invested more in their online shopping setups, and the situation itself has changed, of course. But at the time, the supermarkets were facing significantly increased demand, and online delivery slots in particular were booked up for weeks in advance.
Yes, I remember that well. The toilet rolls crisis, for example, couldn't even get basics like bread and pasta near me.
Yeah, exactly. And you can see how online delivery slots being booked up, that would present a particular problem for people who were shielding. So it was in that context that the government digital service, which is part of the Cabinet Office, was tasked with using data from the list to support those people who were shielding in England through a range of measures. And as I say, sharing data with supermarkets to give priority deliveries is just one example of that.
So what happened, Will? Can you talk us through the steps taken and the key considerations?
Sure. Firstly, this was part of a wider response to the public health emergency. And given the context at the time, the government in England, I think it's fair to say that they could be confident that sharing the data for this reason was justified. I mean, the thinking here was that this could actually help to save people's lives. But then having clear data protection principles in place, that really meant that the minds could quickly be focused on not just whether it could be done, but on the best way of doing it. And for example, we know, don't we, that data minimization is a key principle of data protection. Now here, the shielded patient list initially had data for about 1 million people. I think it has since grown over time. I think it's over 3 million people now, but at the start, as I say, it was around 1 million people. But of course, not all of those people needed help with their supermarket deliveries. Some relied on friends, family, neighbours, or other supports. And for those people who did need support, it wasn't necessary to share all of the information about them on the shielded patient list with the supermarkets. So what I mean by that is that the list contained people's name, address, email address, date of birth, phone numbers, but it also included their NHS number and some information about their medical condition. But of course, supermarkets didn't need to know the person's NHS number or anything about their medical condition. They just needed to know ultimately that the person was eligible for delivery.
That does make sense. And of course, the people shielding probably wouldn't want or expect those details to be shared either, would they? So how did the process work then, Will? What did they do to make sure only relevant data was shared?
Well, the letter was that was sent to these people. First of all, it invited them to seek support through the gov.uk website. I think there was a telephone system in place, and they could go through the process to verify their details and confirm that they did require support. And it was only limited personal data, so name, address, contact details, confirmed through that process that was then ultimately shared with supermarkets. You can see straight away that significantly reduces the amount of data being shared. And as a slight side note, Viv, that process I've just described, it's worth saying that whilst in this situation, consent was not the lawful basis being relied on, I think from memory it was a public task, I think, but certainly wasn't consent. But the process that I've described there, you can see how it would give vulnerable people a degree of control and personal decision making in having their information shared. It wasn't something that was just happening in the background without them knowing.
Mm-hmm. Yeah, I see. Thanks, Will. Well, you can instantly see how by following the data minimization principle, we've very quickly gone from the potential of blanket sharing all that sensitive data of about 1 million to 3 million people to only sharing data that was actually needed to confirm to supermarkets that this person was eligible for priority delivery. Was there anything else you'd pick out?
I think it's fair to say that all of the data protection principles were applied here, as you would expect. Data sharing agreements were put in place, accounting for other considerations, retention periods, deletion of data when no longer required, that kind of thing. I think I would highlight purpose limitation here, though, as another key consideration. I think having a very clear purpose from the start was really important here. The idea was to support vulnerable people in getting food deliveries so that they could then follow the medical advice to stay at home. So, for example, the personal data shared with supermarkets mustn't be used for other purposes. So I'm thinking of wider marketing, that kind of thing. And to help with this, the data sharing agreements put in place allowed supermarkets to cross-reference the data supplied with their own customer records. And where a match was identified, so someone might have a loyalty card, for example, the supermarket could offer priority delivery slots to that person. But where there was no established customer relationship, the supermarket was not permitted to just contact people out of the blue advertising their services.
So of course the vulnerable people here might find that they'd be offered priority deliveries by a supermarket chain that they're used to shopping with, but they shouldn't be receiving lots of contact emails and that sort of thing from other chains they've never used trying to sell their services. Exactly,
yes, that's right. And I think overall, I would say this example shows, again, remember the context of the public health situation. Data sharing was justified. It was to provide support to some of the most vulnerable people in society. And in fact, far from being a barrier, the data protection laws really helped provide a clear framework, as I say, not just for whether it could be done, but how it could be done in the most responsible way.
Okay, well, thank you for talking us through that example, Will. It sounds like by applying data protection principles, the stakeholders involved were able to ensure the scheme could work effectively while also protecting the sensitive personal data of vulnerable people and enabling them to receive online deliveries of food and other essential supplies. And as you say, data minimization and purpose limitation obviously won't have been the only considerations here, but I think they are great examples to show how data sharing can be really valuable. Thanks very much, Will, for that.
Thanks, Viv.
Will is going to stay with us to help with the questions at the end. You can see the key points from that case study here. So let's return to the questions from earlier. Leanne, do you have the results, please? And we'll probably need to read the questions out again from the delegates' answers to questions we asked earlier.
Hi Viv, yes I do. So thanks to those of you who got involved with this. So just as a bit of a recap then, the first question that Viv asked earlier was, have the UK GDPR and the Data Protection Act 2018 created additional barriers to data sharing? And we give 3 possible answers. A, yes, but only where you're sharing large volumes of data. Yes, but only when you're sharing special category data. Or C, no, they have not created additional barriers to data sharing. So the answer is C, no, they have not created additional barriers. And this was answered correctly by 69% of the audience. So very encouraging to see that such a large percentage of people recognise that the new laws do not prevent people from sharing data.
That's really, really good to see. Yeah, whilst the UK GDPR and DPA 2018 have changed some aspects of the law, they haven't created additional barriers to data sharing, and they don't prevent you from sharing data. It is a fact that data protection law enables organisations and businesses to share personal data securely, fairly, and proportionately. If you shared data under the previous 1998 data protection regime, then it is very likely that you can continue doing so under the UK GDPR, along with the DPA 2018. The new legislation makes the position even clearer, and our code provides guidance alongside practical tools to help organisations be confident that they can share data within the law. As a starter, you should have a look at our checklist in the annex, which sets out what you should consider before sharing personal data, as well as what to include in any data sharing agreement. Another practical way to do this is through a data protection impact assessment, or DPIA, which is a process to help you identify and minimise the data protection risks of a project while promoting public trust and transparency. And it also helps you to demonstrate your accountability. And remember, if you're already sharing information in a way that is proportionate and justified, then you should continue to do so.
Thank you.
The next question, please, Leanne.
So moving on to question 2, we asked, can we share data in an emergency? So A, yes, you can share data in an emergency. Yes, but only after a data protection impact assessment has been carried out, a DPIA, or C, rarely. And of course, the answer to this is A, yes, you can share data in an emergency. And 81% of people answered this correctly. 12% answered B to this one, Viv, so it may be useful just to explain a little bit why the answer is not correct in this instance.
They answered B, did they? Yes.
12%, yes.
Yeah.
But a large portion, so 81% answered correctly.
Okay. Right. Well, the 2B is incorrect. You don't need to carry out a DPIA. In an emergency, you should go ahead and share that data so long as it's necessary and proportionate. Use your judgment. It is good practice to plan ahead, as in the example we discussed earlier. Yeah, all types of organisations might have to face an urgent but foreseeable situation. So you should have procedures about the personal data you hold and whether and how you should share any of this information. I mean, that a DPIA could form part of that process. As part of your accountability duty, you should document the action you took after the event if you can't do it at the time. But when it comes to that emergency, no, you'd go ahead. If it's an emergency, you should go ahead and share whatever is proportionate and fair. Looking at answer C, I'm not sure how many people use C. Did anybody say rarely?
7%.
Oh, right. So it's still significant. I mean, that's not correct either. It wouldn't be rare or in exceptional circumstances, unless, of course, people were answering rarely because they were thinking, well, emergencies are rare, I suppose. You should use your judgment, but the top priority is to do what is necessary, fair and proportionate. You can share data in emergency, which is why A is right. You should do whatever is necessary and proportionate to save someone's life and prevent harm. Data protection does not stop that, and sometimes it can be more harmful not to share personal data. The code lists the examples of an emergency situation, such as the risk of serious harm to human life, a public health crisis, like we've just had or are having, or the protection of national security. Organisations should feel confident that relevant personal information can be shared lawfully if it is to protect someone from serious physical, emotional or mental harm. For example, safeguarding in an education context, and where possible, as I've just said, you should plan ahead for different situations and put contingencies in place.
Thank you for clarifying, Viv. So the last question that we asked was, is there much benefit to sharing data? So A, yes, data sharing often brings benefits to organisations. B, yes, data sharing often brings benefits to individuals and to society as a whole. And C, no, any benefits that result from data sharing are usually outweighed by negative aspects, such as potential risks to the rights and freedoms of individuals involved. So there were 2 correct answers on this one. So both A and B are correct. 15% of the audience answered A, 83% answered B. So well done to those who had both answers to this one. I mean, really reassuring to see that people understand the benefits that data sharing brings.
Okay, that's really good. That's really good to hear, isn't it? Yes, this was one where there were 2 right answers. There can be benefits for all at individual, organisational and societal levels. There are potential economic and social benefits to data sharing. It can lead to economic growth. It can lead to technological innovations. Look what's happened during the pandemic. And again, as in the pandemic, it can also improve the delivery of more efficient services targeted precisely where they are needed. Another instance is part of the Digital Economy Act 2017 targets those in fuel and water poverty and also seeks to prevent fraud, all by using data sharing, providing a gateway for that sharing. As I've just said, there was significant innovative use of data sharing during the pandemic, as we discussed with Will earlier. The fast, effective delivery of services as part of the national response to the crisis. And sharing data properly helps to promote trust by data subjects, the public, that their data is being used lawfully, fairly, and proportionately. Thank you very much, Leanne. I think we'll see you later near the end.
That's correct. Look forward to seeing you a little later on.
Thank you. Now, I want to turn here to the ICO's regulatory approach in respect of data sharing. Are you worried about sharing data? I sound like an advert now for toothpaste, but worried about sharing data because of the risk of a large fine from the ICO? Don't be. We hear of misconceptions around how the ICO regulates data protection, especially since the advent of the UK GDPR. Imposing large fines on everybody is not our approach. Don't be put off data sharing because of this erroneous belief. Our approach is to encourage compliance with data protection law, to uphold information rights in the digital age. And we encourage compliance by activities such as monitoring, promoting good practice, offering advice and guidance, and by monitoring and by investigating breach reports. In the next slide, I'll explain some more. The code emphasises that we will take it into account when considering whether you have complied with the UK GDPR or the DPA 2018, particularly when considering questions of fairness, lawfulness, transparency and accountability. But we are a fair and proportionate regulator. We will always use our powers in a fair, targeted and proportionate manner in line with our regulatory action policy. We prefer to work with organisations to seek a resolution. We are as robust as we need to be in upholding the law, but we use sanctions, again, proportionately. We focus our enforcement powers on cases involving reckless or deliberate harms. We don't seek to penalise an organisation that is genuinely seeking to comply with the legislation. So what's next? Our work continues. This is a start. We will develop the Data Sharing Hub as a live resource. Watch out for content being added, including resources relating to sharing children's data for safeguarding purposes. We're keen for you to help us to help you, such as with more case studies and anything else that would be useful to you. Please tell us. Please email your suggestions to datasharingcode@ico.org.uk. That's all one word, data sharing code. We are also planning further engagement with sectors and by topic, and with a wide range of sectors and organisations. Before we move on to answer the questions you've posed to us, as I said at the beginning of this seminar, one of our purposes in drafting the code was to demystify data sharing, bringing together our guidance, setting out good practice and debunking myths. My colleague Will and I have talked through a case study from the past year when the pandemic has brought data sharing into sharp focus. This led to a proportionate, effective approach to an emergency scenario. I've set out also our proportionate approach to data sharing. Don't let the misconceived fear of a fine prevent you from sharing data. But we know there remain some challenges in respect of data sharing. The Data Sharing Code is an important step on the way to overcoming these, and we're looking forward to working together with you and with government to continue the process. Now, we're going to look at the questions that you've posed. Leanne, Will will be joining us here. Thank you, Will. Hello, Leanne again. Do you have the first question for me, please?
I do. So we've had a number of really good questions, Viv, coming through the seminar, which is great. So just a big thank you to all of those who have submitted a question for us. As Viv did mention at the start, as you'll appreciate, we won't be able to answer all individual questions today, but we have been going through the questions during the presentation and a few themes have emerged. So Viv, the first question that has been raised several times is, what do you do about retracting personal data if consent is withdrawn after the share, or do you leave it?
Retracting. Now that is something that I need to refer you to our specific guidance on consent and the withdrawal of consent, rather than going into detail here. I think if you'd like more detail, we could answer that in the hub, but as this is a session on data sharing, it would be perhaps inappropriate to go into that detail here. Looking at lawful basis, our specific guidance on lawful basis will give you more on that. The code does not go into lawful basis in a great deal of detail. It points you towards the ICO website guidance, so I would direct you there.
Okay, no problem at all. So moving on then to the second question, what is the difference between a data processing agreement and a data sharing agreement?
Well, this was something that came up in the first seminar. The code makes clear at the beginning that for the purposes of the code only, we're looking at data sharing between controllers. Data sharing, if you call it that, between controllers and processors is covered by a separate scenario, which is under Article 28 of the UK GDPR, and the code does mention this. It has a few paragraphs devoted to this, and it directs you with a link to our controller processor guidance. So I would strongly urge you to look at that if you're dealing with data processing. It doesn't mean it couldn't include some of the data sharing agreement provisions that we highlight you should consider in your processing agreement, but there are important provisions to follow under Article 28, and you should make sure you follow the law on those as your main priority. I hope that helps, but we have specific guidance on that.
That's great, thank you very much. An interesting question has come up regarding the case study, so on emergency planning. So the question in particular states that, you know, police are processing personal data under the Data Protection Act, Part 3, and local authorities and fire services aren't using Data Protection Act Part 3. So it's a two-pronged question. The first being, so how can they have a data sharing agreement that spans two different legislative routes, so the GDPR and the Law Enforcement Directive, and what does that look like?
I would commend you to look at our section on sharing by and with a law enforcement authority or competent authority. We've got a section in the code on sharing between the UK GDPR and Parts 2 and Part 3. Part 2 is the UK GDPR equivalent, and Part 3 of the DPA, in either direction. And we've also got a toolkit for, as a side point, we've also got a toolkit for small organisations sharing data with the police and other competent authorities like fire services. So I would commend you to read that. Just because it doesn't mean it's impossible to do that. Some authorities actually have to do memoranda of understanding rather than data sharing agreements, but they carry out the same function. I'm not sure if that's answered the question in full or not, but I would commend you to read that, and also our linked guidance, which is highlighted in the code.
Right, okay, that sounds really useful, so I hope it's going to be of benefit to them. I think we have time for just one more question, Viv, if that's okay. So we've been getting a few questions on data sharing agreements. So in relation to this topic, is it necessary to have a formal data sharing agreement in place for a one-off request?
No, it isn't, but the importance of this is related to the extent of the data and the sensitivity of the data. For example, it might just be a very simple request for a small item, in which case it might be disproportionate. But if it's not the size of the organisation or whether it's just one request that is the decider here. It's not mandatory to have a data sharing agreement, but it is really good practice. So if it's a huge set of data or very sensitive data, for example, health or crime related, perhaps about a criminal offence, you should really put one in place. And if you're the sort of organisation that is likely to be sharing data, you should be putting one in place anyway. Plan ahead, as I said previously in another context. That's really important to do, preempt this sort of scenario from happening. And data sharing agreements shouldn't be seen as a burden. It's something that will help you and help improve clarity. It also helps you demonstrate your accountability.
And am I right in thinking that so Annex A of the Code of Practice, the data sharing checklists, they're going to be a fantastic tool for these ad hoc requests?
Absolutely, yes, definitely.
Fantastic.
It's just another tool, and it's also published freestanding in the hub as well. Thank you.
Amazing. So that's the end of the questions, Viv. So I'm going to hand back to you now. Thank you for all those involved. Okay, well, thank you everybody for joining this second seminar. As I said earlier, keep an eye on the Data Sharing Information Hub in our website in the coming weeks for more answers to your questions. Thanks for joining us today. I hope to see many of you at the final seminar scheduled for later this afternoon.